Yeah, thank you for coming today. I'm Nathan Smith, one of the probate barristers at King's Chambers, and I'm joined by my colleague, Rory Goodson, for this Q3 case law update. Now, you may be pleased to know that we're only going to consider two cases from the last quarter, so this seminar will only last about 30 minutes. Rory's going to talk about a case called Oliver and Oliver, that deals with some undue influence issues. But first of all, I'm going to talk about a case from Birmingham decided by His Honour Judge Tyndall, sitting as a High Court judge. That case is called Wood and Fleming. The reference is 2024 EWHC 2398, and judgment was handed down on the 13th of August 2024. So, first of all, what was the case about? Well, the case concerned the estate of a prominent Birmingham solicitor, Mr. Brendan Fleming, a will that he made in December 2020, and a conflict which the judge described as regrettable that arose between his partner, a beneficiary under the will, and the executors of the estate. Now, according to the judgment, there are two sets of proceedings on foot dealing with the estate. One concerned the probate of the will, and the other, which this decision was mainly concerned with, was a claim by the executors for an injunction to restrain Miss Fleming from harassing them. Now, an interim injunction was granted in early July and renewed on notice, and the decision of His Honour Judge Tyndall dealt with whether that injunction should be continued, and indeed whether the allegations made against the executor were unfounded or not. Now, I'm going to skip to the end of that argument. The judge held the allegations were unfounded and continued the injunction. And there's some discussion towards the end of it about the appropriate terms for that type of injunction. But this isn't to talk about harassment or harassment injunctions, so I'm not going to say much more about it, other than if as an executor you do find yourself being harassed by a beneficiary, it might be worth considering further. I think the more interesting aspect of the decision for the purpose of this talk is that the judge commented that each of the proceedings, that's to say the probate and the injunctive proceedings, raised interesting questions of jurisdiction. And in essence, as far as the probate aspect was concerned, it was argued by Miss Fleming that the English court, so the court in Birmingham, couldn't make an injunction against her, not only because she lived in Northern Ireland, but also because it was said that an English court did not have jurisdiction over a Turkish will distributing the property of an Irish testator, as Mr. Fleming was, and indeed his will dealt with some Turkish property, even though it had English executors. Some English property was dealt with by it as well. As I say, it was also witnessed by two people from the West Midlands. But to complicate matters, it turns out that Mr. Fleming may have planned during the COVID pandemic to spend the rest of his life in Turkey, but then in 2023 decided to move to Northern Ireland. Now, the judge didn't resolve the question of domicile. He did, though, look at the question of jurisdiction and deal with some other subsidiary applications. So first of all, jurisdiction. How did the court go about resolving that issue? And how do courts go about resolving the issue of jurisdiction over probate proceedings? Well, the first point to note is not to confuse the issue with that of domicile. The starting point is Section 25 of the Senior Courts Act 1981, which provides that the High Court shall have probate jurisdiction in relation to probate and letters of administration as it had immediately before the commencement of the Act. But that begs the question what jurisdiction the court had immediately before the commencement of the Act. Now, fortunately, that's answered in the judgment at paragraph 49, where it says that Section 25 was preceded by Section 2 of the Administration Justice Act 1932, which replaced the old equitable rule of domicile. And one of the decisions mentioned in this case is an older case of Wayland, which confirmed Section 2, that's the older section, gave the High Court jurisdiction to make a grant of probate, even when the deceased was not domiciled in and left no estate in England. However, Wayland also clarified as has become standard practice, that the court will not ordinarily make a grant of probate unless there is property of the deceased in the jurisdiction, that's say in England. Now, in this case, there was English property, including an English company as well as land in Birmingham. So Section 25 applied and the court had jurisdiction to deal with probate. The judge approved, as part of his judgment, the rule or the summary in Dicey, Collins and Morris on the conflict of laws, Rule 153, which says, in effect, the High Court has jurisdiction to make a grant of representation in respect of property of any deceased person, but in the absence of special circumstances, will not ordinarily make a grant unless there is property to be administered in England. As I say, the relevant issue for jurisdiction is not one of domicile, but once primary or the potential for jurisdiction has been established, the question then becomes whether the court should stay its proceedings on the grounds that there's a more convenient forum elsewhere. The Latin phrase forum non conveniens pops up in this context. So, should proceedings be stayed? That was the next question the judge looked at. The principles for forum non conveniens, or FNC, stays were originally set down by the House of Lords in the Cancelex case, but they've since been summarised conveniently by a Deputy High Court judge in the Assam case. Now, in Assam, the issue was whether the courts in Cyprus would be a more appropriate forum. And as I say, helpfully in that case, the judge broke the test down into two, or identified two limbs set out in the Cancelex case. Under limb 1 of the test, the defendant must establish that the courts in the foreign jurisdiction are both available, firstly, and secondly, are clearly or distinctly more appropriate than the English courts as a forum for determining the dispute. As I say, the burden of proof under limb 1 lies with the defendant, and it's not enough just to show that England is not the natural or appropriate forum for a trial. It also has to establish that the courts of the foreign jurisdiction are clearly or distinctly more appropriate, and that involves something more than an examination of mere practical convenience. If the first limb of the test isn't satisfied, then the inquiry should stop there. Lord Gough in Cancelex said or found it difficult to imagine circumstances where a stay would be granted without another available forum, which was clearly or distinctly more appropriate, being identified. If the defendant then can establish limb 1, it then becomes necessary to consider limb 2. And limb 2 requires consideration of whether, if the foreign courts are available and clearly or more distinctly appropriate for the trial, whether justice nevertheless requires a stay, requires that a stay of the English proceedings should not be granted. Now, one factor that might support such a conclusion is if it's established objectively by cogent evidence that there's a real risk that claimants wouldn't obtain justice in the foreign courts. But the burden of proof on limb 2 lies with the claimants. So that's the general approach. That was the approach that was adopted in this case. And His Honour Judge Tyndall started his analysis by identifying the need for the court to identify, of course, or to work out what the live issues were in the case to evaluate the suitability of the rival jurisdictions. Part of which, in these types of cases, is often a dispute about what the applicable law is that should apply to the will. Now, some diligent research in this case revealed that Turkish law, or under Turkish law, it was the law of Mr. Fleming's nationality, not domicile, that applied to his assets other than immovable property in Turkey. As Mr. Fleming was Irish, it was therefore Irish law that applied under Turkish law. Section 78 of the Irish Succession Act therefore applied, which stated that the formal requirements for will validity were the same as English law, as it happened under Section 9 of the Wills Act 1837. So, regardless of what domicile applied, it turned out that it was English law that governed the formal validity of the will, at least for property that wasn't land in Turkey. The same, incidentally, was true for Northern Ireland if his domicile had turned out to be there, because under Section 5 of the Wills and Administration Proceedings Northern Ireland Order 1984 had essentially adopted the same test for formal validity as English law. So, as I say, the applicable law for formal validity in this case would have actually been the same regardless of whether Mr. Fleming regardless of where he was domiciled. The judge went on to say at paragraph 57 that meant formal validity, testamentary capacity, knowledge and approval, absence of undue influence, all the same as English law, although I treat that grouping with some caution, because while formal validity, that's to say signing, witnessing or due execution, may have been governed by English law, there's a case called Refold, 1966 case, that says that the general rule is clear that the capacity of a testator is to be determined by the law of domicile, although the English probate court still, in all matters of the burden of proof, follows scrupulously its own law. That's another principle that comes out of Dicey, Collins and Morris at 28, I think it's R24, where it says the law of the testator's domicile at the time of making his or her will determines whether or not he or she has personal capacity to make a will of movable objects. So whether in a given case the law that governs issue like capacity and undue influence is English law still needs careful consideration, even if the formal validity requirements are shown to be the same. As you know, there is a distinction that's usually drawn between formal and substantive validity in respect of wills. An interesting point that comes out of that is what the status of knowledge and approval is. And if you do come across the point in a case, it's worth looking again at the Refold authority, because it was held in that case that because knowledge and approval is evidential in character, it's usually applied by the English court, part of its domestic law. In any event, in this case, the judge wasn't satisfied that Turkey or Northern Ireland was clearly or more distinctly appropriate than England to resolve a dispute over the validity of the will, not least because it was drawn by English solicitors on English terms with English executors and minor beneficiaries, and at least and there were some significant assets as well in England. I think that's quite a compelling argument when put in those terms. So he went on then to deal with the applications in the probate claim that were before him. There was an application for summary judgment. It was said by Miss Fleming that the evidence was so clear on testamentary capacity and knowledge and approval that summary judgment should be granted in her favour. Perhaps unsurprisingly, the judge found it wasn't so clear. But it is worth bearing in mind that this is a procedural option, even if it's unlikely to be appropriate in most cases. If you are considering summary judgment applications, also bear in mind paragraphs 5.1, 5.2 of the Practice Directions, Part 57, because you still need evidence of due execution, and the defendant can still cross-examine witnesses to the will if notice is given in accordance with those provisions. Another probate application which was refused by the judge was to remove the executors under Section 50. Again, I won't go into the facts of why that was refused, but it was. One worth bearing in mind, I suppose, is another application that was considered, and that was for an interim grant while a grant pending suit while the probate proceedings went on. That was actually one of the few aspects of that claim that wasn't contested by at the time of the hearing. So, what about some useful points on jurisdiction and applicable law? Well, if you do want to challenge jurisdiction, it's well worth remembering the need to comply with Part 11 to make any challenge in accordance with the procedural requirements there. Another useful section to remember is actually Section 1, the Wills Act 1963. Now, it's not mentioned in this case because it didn't arise, or the point didn't arise, but where a will is executed abroad, it provides that as a matter of English law, the will is treated as properly executed if it conforms to the internal law in force in the territory where it was executed, or in the territory where at the time of its execution or of the testator's death he was domiciled or had his habitual residence, or in a state which at either of those times he was a national. So there are a variety of ways it's possible to make a will valid under that the section. The question of domicile, come across that issue. There's a useful case called Kelly and Pyers, a 2018 Court of Appeal decision, which largely adopts the summary of the law found in Dicey, Commons and Morris, and considers questions of domicile and when a domicile of choice has been acquired. I mean, domicile is quite a complicated area, but in general terms, a person is domiciled in the country in which, as a matter of English law, that person's permanent home is located. But people can acquire a domicile of choice by a combination of residence and intention to permanently reside there. As I say, that was a question that wasn't resolved by Honourable Judge Tyndall in this case, but you can see from that formulation the relevance of whether the deceased intended to permanently move to Northern Ireland or Turkey, as far as the question of domicile is concerned. And then finally, I just thought I'd highlight Section 1 of the Inheritance Act, because that only applies if a person dies domiciled in England and Wales, as made clear by Section 1. In conclusion, I think this case is a useful example of the approach to jurisdiction and FNC stays in probate claims. And it's also an interesting read, I think, if as an executor you happen to be subject to harassment by beneficiaries, albeit you have to bear in mind that you have to reach quite an oppressive level before the court would be likely to intervene. So with that, I'm going to hand over to Rory and let him take you through his case.
Brilliant. Thanks, Nathan. Hopefully now my slideshow will be sharing, and you can let me know if that's not the case, but it looks like it is. So that's good. The case that I'm going to be discussing is a case called Oliver and Oliver. It's a case, the decision came out in September, and it deals with the often linked issues of testamentary capacity and undue influence in the question of making of a will. It deals with the application of the very well trodden test in Banks and Goodfellow, and also raises some issues in respect of undue influence, fraudulent calumny, and an application of the set of principles that was set out in the Edwards and Edwards decision in 2007, which is set out within this judgment. This basic background facts to this dispute involved a family dispute between 5 children, and there are some fairly extreme facts within it and circumstances within it that gave rise to the claim in respect of undue influence and lack of testamentary capacity. I think it's an interesting case in showing how those 2 principles are applied to a particular set of circumstances. And I just thought I'd work that through today and show you how the judge dealt with that decision. In terms of the central facts of the dispute, the parents were William and June, and they executed mirroring wills in 2019. 2009, apologies. Those mirroring wills were intended to divide the estate equally between their children, as at the date of whoever was the latest surviving spouse. There were 5 children, 3 boys, Rodney, Andrew, and Kevin, and 2 girls, Gillian and Jane. June died in 2014, and so the estate passed over to William. In 2015, William executed a new will, which left his entire estate to Rodney, the eldest son, and also made Rodney not only the sole beneficiary, but also the executor of the estate. William subsequently died in 2018. It was at this point that the other siblings became aware of the 2015 will, and it was sought to be challenged by an action brought by Jane, the youngest child, on the basis of lack of capacity or alternatively undue influence that was exercised by Rodney over William. There was an alternative claim brought in the event that this primary claim failed under the Inheritance Act in terms of family dependency and provision for dependents. As you'll see from the manner in which the claim progressed, that fell away, but it was brought in the alternative in the event the primary claim had failed. The basis of the action, and this is why I referred to a very extreme set of circumstances related to Rodney's behaviour. I mean, it's fair to say that he's a fairly unusual character, and his exercising of an increasing level of control over William's behaviour, particularly after June's death. Rodney had previously absented himself from the family for a period of about a decade, but he'd come back and been living with William and June when June had died. He proceeded to exercise a great deal of control over William's life, including what he was able to eat, what he drank, and who he saw. It's also relevant and made out in the evidence and discussed in the judgment that Rodney appears to have been a fairly keen conspiracy theorist. He subscribed to views such as the American government was involved in 9/11, the doctors were all evil, and he was also subscribed to the freeman of the land ideology that I'm sure many of you are familiar with, and is the bane of many a lawyer's experience in court proceedings. He began to exercise this increasing control over William's life. He also exercised control over William's finances. It appeared that he was using them often for his own benefit, purchasing things ostensibly for the house which they now shared together, but in reality was solely for his own benefit, but doing so out of William's estate. He also took William off his medication and prevented him from taking that, and encouraged him to undertake a variety of alternative remedies, is how I think I phrased it on the slide there, including drinking his own urine and something called a hydrogen peroxide purge. I'm not entirely sure what that is. I'm slightly frightened to Google it, but it doesn't sound particularly healthy or pleasant. The other issue that arose was in relation to the running of a family business, which had predominantly been done by his brothers or overseen by his brothers during his period of absence. He raised a number of unfounded or largely unfounded concerns, alleging that money had disappeared from the business, was being hidden from him, and essentially contending that he was being cheated out of funds and that the company had been mismanaged. Through his control over William, he was able to convince his father of this fact, and this led, in turn, to the execution of the changed will in September 2015, where he was named as the executor and the sole beneficiary. What's interesting, or one of the interesting things in this case, is that at the time of the execution, William was certified as having capacity to make the new will. William subsequently died in 2018, as I say, and the other siblings become aware of the 2015 will. They assumed that the 2009 will was still in operation and assumed that they were all going to inherit equally. There was a question raised early on in the proceedings about whether the will was properly executed in terms of its formalities. The judge gave little traction to this and said that on its face it appeared that there had been. What was more important, and the questions that arose, were those of capacity and then undue influence. What I've set out there is the very well-known extract from Banks and Goodfellow, Chief Justice Cockburn there, setting out what has now become the four prongs of tests for testamentary capacity that are often considered. These are that the testator understood the will, understood the property he was disposing of, understood the claims of those, or appreciate the claims of those to which he ought to give effect, and he wasn't suffering from any mental disorders as at the time of the disposition that would have affected it. And I've also set out there underneath a summary of the question of the burden of proof and how that shifts within such matters. This is set out within the Oliver decision at paragraph 106. Generally, the person propounding the will has the burden of proving it. Where it is duly executed and rational on its face, there is a presumption of capacity. Where a real doubt as to capacity is raised, then that discharges the burden on the objector, and the burden moves back to the propounder to establish capacity where a real doubt has arisen. I should say at this point that Rodney didn't engage at all in these proceedings, and that did have an influence later on in terms of his ability to discharge that final burden. Well, his inability to do so. It came before His Honour Judge Matthews, sitting as a High Court judge in Bristol. It was conceded in the dispute that the first two elements of Banks and Goodfellow were made out, that there was no issue in relation to those. The question was in relation to the third and fourth limbs. I've included there some extracts from the findings in respect of the third limb, and pointed out that, and the finding was that the claimant had raised more than a real doubt as to William's understanding of the claims to which he should give effect within making the will, and highlighted in his paragraph 122 that William understood everything only through Rodney's point of view and had ceded all decision-making to Rodney. Rodney's not having engaged in the proceedings meant that once that burden then shifted onto it, he was unable to discharge it. And as such, the judge set aside the 2015 will. He also made a finding on the fourth ground, noting that questions of cognitive abilities had arisen, and considering some of the medical evidence. I'm not going to deal with that in detail here because I think it's in relation to the third limb that it's more interesting in this decision. Notwithstanding that finding, he then went on to consider the question of undue influence, which, as I say, is often tied together in such cases. What I've set out there is a series of criteria that is noted within the decision of Mr. Justice Lewisham in Edwards at paragraph 42. It's quoted in the Oliver judgment, and I've just noted them all down there and summarised them all there. I just run through them quickly. As I said, there's no presumption of undue influence when it's a testamentary disposition. Whether there is undue influence it is a question of fact. The burden lies on the party asserting that there is undue influence. In terms of what can amount to undue influence, this is influence exercised by coercion or by fraud. Coercion can be made out by pressure that overpowers the volition of the testator without necessarily convincing the judgment is the manner in which the phrase within that decision is used. The physical and mental strength of the testator are relevant factors. In terms of fraudulent calumny, this requires a poisoning of the testator's mind against the natural beneficiary by casting dishonest aspersions on that person's character. The accused must know that the aspersions are false or not care if they are true. And finally, and this is the sort of overarching principle here, is that the question really is whether the testator acted as a free agent when was executing the will, or was there some kind of overriding force or overbearing force upon them, which vitiated this. His Honour Judge Matthews again found that there was undue influence here, for the same reason, on the basis that William was so far under Rodney's thumb and so in fear of losing Rodney and the dependence that he placed upon him, that by the time he made the will, he could not have done otherwise than go along with Rodney's wishes. It was based on this complete control over William's life that Rodney had come around to being able to exert. As I say, I highlighted some of the more unusual factual elements earlier on. While William was in hospital prior to death, there were further instances that arose. There's some evidence of a nurse finding that William's colostomy bag was being emptied, and it was appeared that he was being fed his own urine by Rodney while he was in hospital, and situations such as this, which were used again as evidence demonstrating this kind of complete control and dominance that was being exerted over every facet of William's life. I've put up there some takeaways from the decision and maybe some thoughts. I appreciate we've just run past the half-hour time frame that was set for this. It is clearly a very extreme set of facts here. The level of dependency and the conduct of Rodney in this case is clearly an unusual one and goes at the extreme end of the spectrum from such things. But there are some interesting points, I think, that can be taken from this. Firstly, in relation to testamentary capacity, This is often a principle that arises when you're considering questions like dementia or extreme old age. What we had here in the finding on the third limb of Banks is actually that's not necessarily applicable. The testator was found to be, able to provide detailed instructions to produce the will, and on appearances have capacity to do so. But there was this underlying malign overbearing of his ability and overtaking of his capacity that was at play and that was made out when considering the broader circumstances of Rodney's actions. And when it comes to undue influence, I think there's particular interest here in terms of the evidence that was applicable and the evidence that was considered. The judge made clear at one point within the decision that findings will necessarily be partially circumstantial in these cases. It will have to consider evidence rather than the mere execution of the will, but the surrounding circumstances that display the relationship. And in this case, the judge would also consider evidence that took place after the execution of the will, because it played into the broader considerations of allowing him to make the findings necessary to answer those questions posed by the claim for undue influence. So as I say, the will was then set aside and 2009 will was reinstated. Thank you all for attending. I'm told that the video will be sent out to all attendees. You should also be receiving in due course all the various slides that have been used. I hope that was interesting and useful. And as I say, thank you all for attending, and good afternoon.